we are going to invite to give remarks Dr. James D. Diamond. Dr. James D. Diamond is Dean of Academic Affairs at the National Tribal Trial College. He is the former director of the Indigenous Peoples Law and Policy Programs Tribal Justice Clinic and a law professor at the University of Arizona College of Law. Diamond taught the Tribal Justice Clinic, tribal courts/tribal law, criminal law, and criminal procedure there. Dr. Diamond was a special prosecutor in the Pasquayaqui Tribal Court in Arizona, is certified by the National Board of Trial Advocacy as a criminal trial specialist, has extensive criminal trial experience, and was the lead lawyer in more than 1,000 criminal cases. Dr. Diamond's academic research focuses on the aftermath of mass shootings and restorative justice. He is the author of the recent book, After the Bloodbath, Is Healing Possible in the Wake of Rampage Shootings, as well as numerous articles on the practice of law in tribal courts. Dr. Diamond obtained a doctoral degree, SJD, in Indigenous Peoples Law and Policy from the University of Arizona College of Law, a Juris Doctor, JD, from Brooklyn Law School, and a bachelor's degree, BA, from the State University of New York at Albany. Today, to share remarks on why I'm the wrong speaker for today's conference in search of my replacement, the fantastic Dr. James D. Diamond.
Good afternoon. Can everyone hear me? Okay. Thank you so much, Two Hawks. And I am really honored to be here today. First, let me say how grateful I am to join with the other speakers who preceded me. That's kind of hard to go late in the program after these kinds of presentations. I recognize your guest of honor, Lord Thomas, who spoke about some of the things I'll talk about as well. I'm pleased to appear on a program with Sagamore Guy and Sachem Dancing Star Brown of the Pokanokets, my colleague, Dr. Carrington Farmer, and I too join with all of you in honoring a wonderful man who I'm so pleased to see here today, Dr. Bangs. Dr. Bangs' work has been heralded here today. I don't go anywhere without Indian deeds that I've spent a great deal of time studying as well. Dr. Bangs, it's not easy to swim against the tide, which Dr. Bangs has done, like the salmon that are so sacred to many of the indigenous people of the Northwest. And Dr. Bangs' career, it is not easy to do that. I can tell you that as someone who occasionally also swims against the tide. So I join with all of you in honoring Dr. Bangs' work, his lifetime. He is fitting for the Lifetime Achievement Award. I'm here to tell you why I shouldn't be here. I'm here to tell you why I'm the wrong person to be speaking today as a non-Indigenous person speaking at a conference of Indigenous peoples. But I am honored that you did invite me. But as I tried to figure out what I was going to talk about this afternoon, and I reflected on the 400-year anniversary of the treaty between the Massasoit and his people who are here today, and the settlers at Plymouth. What I wanted to call for was a new peace, and a new peace like the one that the Sagamore spoke about. A new peace, a new kind of peace agreement, a new kind of treaty between the United States and the state governments who have never been included in treaties before, and the Indians of the Northeast in particular. I wanted to talk about a new kind of peace among Indigenous peoples here in the Northeast and elsewhere, but mostly here in the Northeast. The Indigenous people of the Northeast here, some 383 years after the end of the Pequot War, are still battling over territories. And the colonial government is still benefiting from that divide and conquer strategy, which has been the strategy of at least 400 years. Today, the battles end up in courts, which is where I do my work mostly. The battles end up in courts as Native nations fight with one another over territories for casino gaming, for example, as they beg for permission from the colonizer to economically develop, to build casinos, or even as they battle in courts over recognition of one another. It's so common that it's Native nations who fight against others' recognition. I wanted to talk about the modern crisis of Indian tribes violating civil rights of their own people. I wanted to talk about that violation of international human rights, which is one of our themes for today. The international human right of citizenship, of nationhood, which is guaranteed Indigenous people in the United Nations Declaration on the Rights of Indigenous People, Article 6. Yet it's Indian tribes themselves denying civil rights, often after tribal nations realize the benefits. For the first time in hundreds of years, as a result of casino gaming. I wanted to talk about all that, but I said I can't. I can't talk about that. How can I be the person who talks about that? How can I give a talk to Indigenous people about Indigenous governance? What right do I have? I'm not Indian. What right do I have to weigh in on Indian governance? What credibility do I have? What credibility does the Jewish guy from New York City have with this audience to talk about this? As a non-Indian lawyer, as a non-Indian law professor, what rights do I have to speak about? Now, we heard a few minutes ago my good friend Chief Fisher talk about legitimate allies, and Dr. Bangs is an ally. I hope that I am too. My friend Letitia Stover, some of my students know, who is a judge of the Navajo Nation District Court in Kayenta, up in the Four Corners, a beautiful part of the earth. She said to me, Professor Diamond, allies have been important to the Navajo people and have been important to me in training me to get where I am today as a Navajo Nation judge. I wouldn't be here without allies. So I understand the role of allies, but seriously, I wondered, how can I be the one to call for these new peace accords? How can I do that when the United States has never grappled with the policies of 400 years that led to where we are today, where Indigenous peoples are today all under the guise of law, something which Lord Thomas spoke about, all under the color of law. In considering the history of the treaty we honor today, let's think for a few minutes about the way the Indigenous peoples of the Northeast felt about the treaties of those years. My teacher, my good friend, my mentor, the Honorable Robert A. Williams, Jr., wrote about one of those treaties of this period. And this was the treaty that was made in 1613 between the Haudenosaunee and the Dutch. And it was a treaty in 1613 which would govern the way the Haudenosaunee Confederation and the Dutch would live with each other, and would live with each other in perpetuity, forever. It was a concept of forever. The Haudenosaunee made a wampum belt to record the treaty. That's how the treaty was written, by the Haudenosaunee. This treaty, which was called the Caswentha, is a wampum belt that had two rows, two rows, and there were purple rows that ran alongside of each other. And those two rows represented two ships, two vessels. And this is what the Haudenosaunee said about the Treaty of 1613 with the Dutch. One boat is the canoe with the Haudenosaunee way of life, its laws, and its people. The other side is the Dutch ship with the Dutch laws and ways of life. The boats will travel side by side down the river. It's the river of life. They will travel side by side down the river of life. Listen to this. Each nation will respect the ways of each other and will not interfere with the other. Quote, together we will travel in friendship and in peace forever, as long as the grass is green, as long as the water runs downhill, as long as the sun rises in the east and sets in the west, as long as our Mother Earth will last, unquote. Now, what a beautiful image. Two ships, two vessels, traveling side by side in perpetuity forever. A beautiful image. Well, we know that's not the way it turned out. Not only did the ships not travel down the river together, peacefully side by side down the river, the Europeans tried to sink the canoe. Think about that. But that's how the Indians felt about the treaty. Side by side forever, respecting each other's ways of life. Well, we know what the rest of history was like. That brings us into the modern era of treaties, more recently than the 1600s. As more and more treaties were signed and treaties became the official policy of the United States, the official manner of nation to nation responsibilities and relations, it became the official policy of the United States to break the treaties. That was the policy of the United States, to break the treaties. And the United States never denied that that was the policy of the United States. That was the official policy, and the United States never denied it. So, as an example, when the Medicine Lodge treaties of the 1860s were negotiated between the United States and many tribes, plains tribes of the Midwest and the Southwest, and representing many hundreds of thousands of indigenous people. When the Medicine Lodge treaties were abrogated, broken by the United States as the US attempted to satiate its appetite for land, its appetite for assimilation, as it tried to fulfill its policy objective of assimilating Indians to the point of destruction, genocide, invisibility. As it broke that treaties that were negotiated in good faith not all that long ago, right? Relatively recently. As the US broke that treaty, it went before the United States Supreme Court. And what did the US Supreme Court say about the policy, the US official policy of breaking treaties? Here's what the US Supreme Court said in a Supreme Court case of Lone Wolf versus Hitchcock in 1903. And let me quote the United States Supreme Court. This is the law of the land. It was the law of the land in 1903, and it is the law of the land today. Here, quote, the contention that Congress could not divest the tribes of their lands, except according to the terms of the treaty, in effect ignores the status of the contracting Indians, the status of the contracting Indians, and the relation of dependency they bore and continue to bear towards the government of the United States. And the Supreme Court of the United States in Lone Wolf continued, quote, when therefore treaties were entered into between the United States and a tribe of Indians, it was never doubted that the power to abrogate or break the treaty existed in Congress. This is the United States Supreme Court talking about breaking a treaty with hundreds of thousands of indigenous people. And it came before them and they said, you have to consider who you're talking about. These are Indians. They're inferior. And this is troubling language, okay? And it's not my language, it's the language of the Supreme Court. But you have to consider, okay, this history when talking about treaties, which we're here to talk about here today. And so I thought to myself, how can I call for a new peace accord? A new peace accord between the United States and indigenous peoples. A new peace accord among indigenous people. How can I call for that when the United States has never reconciled with that court decision or so many other destructive court decisions like Johnson versus McIntosh, which announced for the legitimacy of the doctrine of discovery. Cases like this, which are still cited today as law. Still cited today as law. Cases like this, which have never been repudiated by the United States Supreme Court, never been repudiated by the United States, never been repudiated by the state governments as well. How can I possibly grapple with that history? How can that policy of abrogation of treaties, of breaking treaties, how can that policy possibly square with international law? One of our themes today is international human rights law. How can that policy of breaking treaties possibly square with international human rights law, with all of the documents of the United Nations and international relations? How can that possibly be an international legitimate policy? And as I wrestled with being a non-Indigenous speaker at an Indigenous peoples conference here, as Professor Farmer also did, right? I find myself here today in the awkward position of replicating the non-Indigenous practice of thinking I know better. Some mention was made earlier about Canada. And let me talk for a second or so about Canada. In 1991, when the province of Alberta, the provincial court of Alberta, was analyzing its own history of how its judiciary treated the Métis and other Indigenous peoples of Alberta. And by the way, I also apologize, as my student Mario McLean did, if I mispronounce any of these words or terms or peoples, and I do apologize. But in 1991, they issued a report on justice in Canada. And here's what the chief judge of the provincial court of Alberta said about Canadian policy. Quote, "Everything that has worked when we're dealing with natives has come from natives. I don't know of anything that has worked that has been foisted upon them from up above." Even that concept of above is a reference to hierarchical power that is part and parcel of Western Anglo jurisprudence and is not Indigenous. But nothing has worked that we have forced upon the Indigenous people. It's only worked when it is organic and has come from them. And I think that observation is profound. I think it applies more to the United States than it does to Canada. When you think about what has been forced down the throat of Indigenous people in this genocidal policy and history, or this attempted genocide, which has been thankfully unsuccessful. But if you think about the forced trauma that the United States has imposed upon Indigenous peoples, let's just pause for a moment to think about 6 policies that have been forced upon Indigenous peoples in the United States, which have been an abysmal failure over the last several hundred years. 1, this notion of quantifying blood quantum. Some mention of it was made earlier. But this policy, which the US government invented, of figuring out who's an Indian by quantifying how much Indian blood flows through their veins, as if they're thoroughbred racehorses that Dr. Farmer talked about, or champion pedigree pets. Okay, was invented by the US and is not something which has aged well and should be abolished. Number 2, the policy of the United States of assimilation, which was the policy of the colonial forces and all of the colonizing forces, then later the British, then later the United States. The policy of turning Indians into Christian farmers, okay, is at the root of all of US policy. And it was easier to win by assimilating the Indians and making them invisible, okay, than it was to fight wars. George Washington, as a general, said, why should we fight wars with the Indians? It's way too expensive, okay? And remember, the Indians are like the wolf. You can push them to the exterior boundaries of the forest. They're just going to come back. Just make deals with them. Make treaties. he said, let's stop fighting these wars. This is the legendary, quote unquote, white father. Assimilation, number 2, of Indians to become Christian farmers. That's number 2, the second forced policy that I want you to think about as a contributing factor toward how we got where we are today. Number 3, allotment, the Dawes Act. This was another element of assimilation, but where the U.S. said, okay, we're going to take native lands, we're going to take indigenous lands, and we're going to carve it up. And rather than have tribal properties, community property, we're going to give it to the Indians. Everyone's going to have a little piece of land, a little piece of the American dream, and you're going to farm it. We're going to make you into farmers. So we're going to give you a little piece of land. And this was the Dawes Act, which then recorded who were Indians, right? Who had the necessary blood quantum, right? But it was a horrible failure, as the Indians ended up losing most of that land too. Not only did the treaties take away the land from the indigenous people of the United States, but the Dawes Act did as well, because the parcels got divided and subdivided, and then the Indians lost so much of the property due to the tax collector. And so the Dawes Act and individual property ownership for the purpose of becoming Christian farmers was the third horrible failure, which resulted in this forced trauma that brings us to where we are today. Number 4 in my list of horrible failures that brought nothing but trauma. Number 4 is residential boarding schools. Residential boarding schools, which were also tools of assimilation. We're going to take Indians off the reservation. We're going to take Indians away from their families. We're going to cut their hair, change their clothes, and teach them how to be white Christian farmers, how not to be Indian. These boarding schools, residential boarding schools, ended up becoming dens of mental, sexual violence, cultural abuse, and tore apart indigenous families. To this day, there are people alive today, still today, who went to these residential boarding schools and still to this day suffer the consequences. In many ways, the crisis in indigenous communities of domestic and sexual violence goes back to this residential boarding school policy. One of the contributing factors of this crisis. Boarding schools tore apart families. Not only are there people today who are still alive, so many who have survived the boarding schools, there are so many people, indigenous people today, who have been torn away from their families in the successor to residential boarding schools, and that being adoption out of indigenous families to non-indigenous families. Okay, ready for number 5? Number 5 in the list of forced traumas that contribute to where we got to today. Number 5 is something that I deal with every day, and that's Western systems of law and court systems and the rule of law, which was imposed upon indigenous people and is imposed today with the leverage of, if you want to be able to be given permission to have tribal courts, then you got to do it our way. You have to do it. You have to follow our rules, and you have to guarantee the rights that we tell you you have to guarantee. But just think for a minute about what the rule of law and a court system does to Indigenous people. And Sagamore spoke about this. And Sachem Dancing Star also said she was a storyteller, right? We know how important storytelling is to Indigenous people, right? In fact, I remember once I was a tribal prosecutor, and I went to go seek advice in a sentencing case, and it was a sentencing case in an armed robbery of another tribal man, and I was the prosecutor, and I asked for advice from community people. I wanted to make a speech about how this is not the way of this people, that the court that I'm a prosecutor in, but I'm not Indigenous, and I want to know how can I make that speech. And I was told that you really can't make that speech, but instead we'll tell you a story. And that's where I learned the importance of storytelling. But think about this for a minute. How can you tell a story that perhaps has an animal like a deer or a rabbit or a wolf as an analogy? How can you tell that story in a court when the rule of law says it has to be quote unquote relevant to the point that's being made in court? Or how can you have a court system? How can Indigenous people thrive in a court system when you're not going to allow elders to speak? That's hearsay evidence, out of court statements made for the truth of the matter asserted. That all of these systems, all of these rules of law, the rules of evidence, the rules of Western Anglo jurisprudence are foreign to Indians. Okay, it's not a cultural match. That's number 5. What's number 6 in forced trauma? Number 6 is patriarchal systems. Patriarchal systems that replaced Indigenous matriarchal systems, where women were honored, where women were given the responsibilities of so much. We replaced that, or that was forced upon them, like the Chief Judge said. Patriarchal systems which, if you think about, again, like I talked about earlier, the crisis in Indian country of domestic and sexual violence, this is a contributing factor. This replacement of patriarchal power and control replaced matriarchal control or power or influence, which was so prevalent in Indigenous communities and a major contributing factor to the violence that is now imposed upon Indigenous people, sadly. So, if you take my 6 forced traumas, right, and you look at that, okay, now add to that the following, okay, when considering my discomfort at being a non-Indigenous voice. If you think about that, why aren't there more Indigenous voices? And the ethics of that, as Dr. Farmer pointed out. I want you to think about the following next, after the 6 forced traumas. Think about the following. And these are the failures of education in the United States. Failures of, first, let's talk about the failures of K through 12 education and educational policy as a contributing factor to there being insufficient Indigenous voices coming to the surface One, and that's the failure of the US to adequately fund the education of the indigenous people in school. It's simply inadequate. It's simply not a priority. That's number one. Number two, the US history of education that teaches an inaccurate history that's just wrong. And think about how that impacts the indigenous youth. When they come home from school and they say, we learned about Thanksgiving. We're running around in costumes. We learned about the history. We learned about manifest destiny. We learned about the statues. We learned about how Columbus should be, as a hero. Inaccurate history, wrong history, and think about the impact that has on Native students, and the fact that that's taught to everyone, Native and non-Native. Think about the impact that has on the youth in the classroom, growing up and listening to that. Number three, K through 12 educational policy, the failure to hire indigenous teachers. The failure of the inability of youngsters to see people like themselves as teachers in the classroom. Think about what an impact that has on indigenous youth and the raising up of indigenous voices. Number four, think about the fact that indigenous youth are disciplined, punished in school at a substantially higher rate than non-indigenous students, whether that's suspension or expulsion from school or placed in some lesser alternative education program. Think about that impact that has on indigenous voices. Number five, in considering K through 12 education as a contributing factor to indigenous voices, think about how students at school are insulted or demeaned. First of all, demeaned or insulted outright, or implicitly by the use of stereotypes and sports teams named after indigenous people in a demeaning, insulting way with use of mascots. Now, a little bit of progress has been made on that front, like yesterday. But it's a small amount of progress. It is progress, as this year, finally, sports teams are by the hundreds, maybe thousands, around schools in the United States are changing their names. But think about how that impacted indigenous voices to be made a mascot, and the mascots running around on the field in ridiculous costumes. Think about how all of these factors contributed in a negative way toward there being indigenous voices. Is it any surprise that there aren't more indigenous voices? Now, moving on from K through 12 to my realm and Dr. Farmer's realm of academia. If you add in the failure of the academy to promote indigenous scholars, to promote PhDs and fellows, and to fund scholarships for indigenous people. If you add in the failure of the academy, failure of our institutions of learning, failure of colleges, universities, graduate schools, and law schools, there's serious failure of academicians and campus leaders to make Indians feel welcome on campus. Okay? If you add that in, how could you possibly end up with sufficient honored Indigenous voices? How could you possibly be surprised after everything I've just mentioned? Well, you're not going to be surprised. And as I reflected in my preparation for today on my own career, this has come up over and over again in my career. My wrestling with not being Indigenous and yet being a scholar in this field and a professor in this field and a lawyer in these courts. I wrestled with it all the time. It's come up all the time. I'm reminded of a story. And a few years ago, I went for an interview to be the chief judge of the Hopi Nation. And my students have heard this story before, so I hope they will bear with me as I tell our audience this story. I went for an interview to be the chief judge of the Hopi Nation, chief judge of the Hopi Tribal Court, which has a very, very sophisticated tribal court in a very, very well-developed body of law, both positive law, statutes and ordinances, and common law, case law. So here I am on in the capital of the Hopi Nation in Kikitsmovi, and I'm being interviewed to be the chief judge. And Wayne Taylor, who was part of the interview committee, is the former chairman of the Hopi Nation, a traditional Hopi from Shungapavi village. And he said to me, he said, "Mr. Diamond, shouldn't we have a Hopi chief judge?" And I said, "Yes, yeah, you should." And I talked myself out of the job. I didn't have to replace myself in that position. They didn't let it get that far. They did it first, and they were right. The search for Indigenous voices plays out quite frequently in my profession, in tribal courts. You see it every day when tribal judges are trying to weave in tribal customs and traditions into a tribal common law. But that's extremely difficult to do. It's extremely complicated under the best of circumstances. It's a task that many Indigenous scholars say, don't try it. Like, for example, Pat Sikia Kwaptua, a Hopi scholar, cautions against, don't even try it. But what emerges is a great skepticism of us non-Indigenous academics. The anthropologists, non-Indigenous anthropologists, like Dr. Farmer, who I don't mean to insult, or researchers or scientists. Ryan Deloria, who was already quoted here once today, of Standing Rock Sioux tribe, once joked, "Indians are certain that Columbus brought anthropologists on his ships when he came to the New World. How else would he have made so many wrong decisions about where he was?" Professor and Tribal Court Judge Matthew Fletcher of the Grand Traverse Band of Ottawa and Chippewa Indians, writing about tribal courts and reliance of non-Indigenous anthropologists and scientists, wrote, "There's a significant bias of Indian people against the word of these academics." I have great admiration for Professor Fletcher. The only thing I don't understand is how he continues to be a Detroit Tiger fan. But as a Met fan, it's completely understandable. And Navajo Nation Supreme Court Justice Tom Sow, in a Navajo Nation 1983 case, said this about tribal courts relying on non-Indian academics, quote, "The Diné are the most accurate commentators on themselves. Studies of Navajo are incomplete, inaccurate, or don't reflect the current state of Navajo common law. So in my previous positions as director of a law school tribal clinic, as a former tribal prosecutor, and in my current positions as an Indigenous law professor, as the dean of an organization that fights for victims' rights and trains victims to be advocates in domestic and sexual violence cases, in that position, in my position as a justice in tribal court with Chief Fisher here, in my current positions, I've always trusted that my job, my responsibility was to contribute what I can, what I possibly can, to right a 400-year wrong, to help reverse for the 400 years of trauma, to raise up, my responsibility is to raise up the next generation of Indigenous voices. Now, I can afford to do this. As a person of privilege, educated at expensive schools, with a spouse who has an exceedingly generous employer, I can afford it. I'm confident, I'm very cognizant. I recognize the privileges that we've been afforded. And that's why we can afford to volunteer. But not everyone else is in my position. Another son of New England, President John F. Kennedy, recognized the debt of service as he took the mantle of leadership, leaving nearby Massachusetts. He addressed the Judicial Conference of Massachusetts, saying the now famous words, "For those to whom much is given, much is required." And then President Kennedy said that each of us would be judged, quote unquote, at some future date, when, quote, the high court of history sits in judgment on each one of us, unquote. Our lives would be measured by several questions. And he said, this is question number 2, that our lives would be measured by, quote, were we truly men of judgment? By the way, apologies to the women. Were we truly men of judgment, with perceptive judgment of the future as well as the past? Were we truly men of judgment, okay, understanding our own mistakes as well as the mistakes of others, with enough wisdom to know that what we did not know, and enough candor to admit it? So when we possess the wisdom to admit our mistakes, then we'll be ready to begin to confront the painful trauma of the past and to make a new peace. Peace with the United States, peace among the indigenous nations, a new peace. And yes, as has been recognized here today, there are indigenous voices here in Rhode Island and in neighboring Massachusetts and Connecticut. My friend Shannon O'Loughlin, the director of the heralded and noteworthy Association on American Indian Affairs, who's Choctaw, told me the following: Native Americans have been made invisible in so many places. Not the kind of invisible when we aren't there, the kind of invisible when we are there, standing right in front of you and you still don't see us. My friends, you are on the program here today, and you are in the audience here today. I see you here today. We see you here today, and we honor you here today. Thank you very much.
Another round of applause for Dr. Diamond, please. A few questions that were posed in the chat, so I'm going to read them off for those of us who can't see them. Oh, yeah, okay. Hold on one second. Thank you very much, Touche. So the first question is, are there any penalties under international law that can be applied to the United States for breaking its treaties?
He smiles
Wow.
large.
What question was that?
That was from Dr. David Weed.
Thank you, Dr. Weed, and recognize Dr. Weed's work with the Soam's Heritage Project. Fantastic. Penalties under international law. That's a great question. I guess the short answer is no. International human rights law depends on the following of international law by member states. It's voluntary, and so there are no penalties. And so the United States can decide to what to follow and what not to follow by deciding what treaties to sign on to or not sign on to. And the United States doesn't have a very good record in this field. I know that will surprise some of you, and others of you will say, duh. Yeah, right. The United States has a horrible record. Do you know that our speaker this morning, Lord Thomas, spoke about the International Criminal Court, and he has been involved with the International Criminal Court. Do you know that the United States does not recognize the International Criminal Court? The United States has never signed on to the Rome Treaty, creating the International Criminal Court. The United States is not a party to it. So the short answer is no. You can bring, look, I don't want to be facetious, because you can bring cases before the United Nations, before the various treaty bodies around the world, before the treaty bodies here in the Americas, the human rights commissions and courts. You can bring cases, and there have been victories, like down in South America. There have been victories, and in the West, there are a few victories, but they're few and far between, and they require member states to show up, to respect them, and to follow them. I do want to just mention something about human rights while we're on the subject, because of the question. I think it's time for tribal courts and the several hundred tribal courts and tribal nations to use international human rights in their courts, and to recognize the various conventions and treaties as a body of law, and to adopt the United Nations Declaration on the Rights of Indigenous People, and to follow it and to use it. So great question. I hope I've answered it. I think probably exhaustively.
Very good. Thank you, Dr. Diamond. We have another question. This is from Akiki. It says, what are your thoughts on the Blackmar decision of 1910 regarding the Montauk tribe and the subsequent impact it had on the tribe and the land?
I'm not familiar with it. So I apologize. And, I think that the best thing a professor can do is say, I don't know.
Absolutely.
So if you can send me information about it, and Two Hawks or Dr. Palermo or Mario McLean will share with you my email address. Send that along to me, and I'll respond further.
Very good. Next question, and this is from family, Dana Washington, Nipmuc and Narragansett family. Question to Dr. Diamond. As a non-native, what initially inspired you to devote your research and work to the field of Indigenous ways of life and studies?
I get that question all of the time. Well, So I was practicing law in nearby Connecticut for 25 years. I was a state prosecutor in Danbury, Connecticut, and then for 7 years, and then I was a criminal defense lawyer all throughout Connecticut for 20 years. And I was extremely frustrated with my experience in court. By the way, I'm a reformed prosecutor. And so I was frustrated. And then in all honesty, the Great Recession of 2008, 2009, 2010 hit. And whereas previously I thought that being a criminal defense lawyer was recession-proof, this one was not. And so I was always interested in the West and the Southwest in particular. I had only passing recognition, like all the rest of my fellow non-Indigenous lawyers in Connecticut, only passing recognition with the Pequots and the Mohegans and some of the other peoples of Western Connecticut, like the Golden Hill Pogussets and some of the others, only passing familiarity. And so, but I had been going to Arizona for many, many years, and my parents retired there, and so I was there. My daughter was applying to the University of Arizona as a college undergrad. And so I went to go look at the campus for her, and there I was, and fell upon the Indigenous Peoples Law and Policy program at the University of Arizona Law School. I couldn't believe that it existed. I couldn't believe that there was an entire law school program with half a dozen Indigenous scholars, where Vine Deloria created the program. I couldn't believe it was there. So I started studying and reading, and I said, you know what? I'm going back to school. I closed up my practice. I closed 100 criminal cases, files, closed it up, closed the office, and went to Arizona at age 50 to go back to school. I was the oldest person in all my classes, but that began my road. And I was halfway through my coursework. And I had just taken tribal courts with Justice Raymond Austin of the Navajo Nation Supreme Court. I had just taken tribal courts with him. And I got off the airplane at John F. Kennedy International Airport during the winter break. And I looked up on the television and I watched what happened in Newtown, Sandy Hook Elementary School, before my eyes. I couldn't believe it, because here I was, an attorney. Newtown was part of my territory as a state prosecutor. I had friends there, I had clients there, and I watched what was happening there. And I was very disturbed. And I was disturbed with several things that happened in the community, including the way people turned on one another. I said to myself, I wonder if there's ever been a school shooting on an Indian reservation. And I found one at Red Lake High School in Minnesota, on the Red Lake Reservation of the Chippewa Indians. And I began to study it. And I studied the way the Red Lake Chippewa treated each other after a mass shooting, after a school shooting. By the way, a subject that's sadly in our news every day this week. I looked at the way the Red Lake Chippewa treated one another, and the way that they treated the shooter as one of their own, and never turned their back on him, saying, he's someone's uncle, he's someone's brother, he's someone's cousin. And they honored him and honored his family. And so that's what I decided to write my doctoral dissertation about. And that became the book, After the Bloodbath, Is Healing Possible in the Wake of Rampage Shootings, which is my book about comparing Indigenous dispute resolution to non-Indigenous dispute resolution. And that, Dana Washington, is my story.
Very good, Dr. Diamond. Thank you. And we have one last question before we move on to our next discussion. This comes from an individual who's very distinguished and very well achieved, and someone that I think we all look up to, Dr. Taino Palermo. He asked, Dr. Diamond, can you talk briefly about the Dan case in the Inter-American Commission on Human Rights and any impact or hope the case may provide for other tribal nations?
Thank you very much, Dr. Palermo. And I would echo Tuhawk's sentiments about Dr. Palermo, and you've seen him here today. And I want to recognize all the work that he's been doing for Indigenous people all around the world, his studies, his scholarship. But look, I just want to tell you, Dr. Farmer can echo this. Just imagine how proud I am of my students, Tuhawks, Dr. Palermo, Mario McLean, here today. How proud I am being their teacher, and how much I learn from them. Like I think I probably was when I went back to law school. I was it's like having another teacher in the room. That's how I feel about these three people, and many of my students, many of which are also listening here today. But Dr. Palermo brings up the case of the Dan sisters, two sisters who brought a case in the Inter-American Commission on Human Rights, which, by the way, sits in Washington, D.C. And in fact, it was my program and my colleagues that brought that case, that represented the Dan. It was my colleagues and James Anaya, who became the special rapporteur on Indigenous peoples, who brought the case, who represented them. And in fact, Dr. Palermo, you make a very good point. The Dan case, who were Arapaho, Indigenous people from Colorado, were successful. It's one of the very, very few wins. And in fact, that and the Agostini case from South America, Agostini, which, by the way, I'm also proud to say was also brought by my program. These cases are rare wins in the international human rights courts, and therefore they're cited routinely as precedents. But they're rare wins because Agostini was a case of recognition of mining rights and the rights of Indigenous people to what's under the surface, usufructian rights of what's below the surface. And these two cases are among the two victories, and it shows what's possible. It shows what's possible. These cases take years and years and years to bring. It's very difficult to get hearings, right? And then if you get hearings, it's very difficult to get the member states, quote unquote, to abide by them. But these are two cases where they were abided by. So it's a little bit, a sliver of optimism, When I say that these cases take years to bring, it's another example of when you practice in this field of law, you can't you can't, use the Western tool of the watch, right? You can't have a short-term view. You have to have the long view. It's one of the things I learned when I went back to school, because I used to like to close up my papers, put away my files, and move on to the next case. And I did that in criminal cases. But the long gains, the long march of civil rights, the long march of indigenous rights is not for the weary. It takes an incredible amount of work. It's worthwhile. It's worthwhile. But it could take you a generation. If you think about our brothers and sisters who are federally recognized, right? It took them 20, 30 years of fighting to get what they wanted, right? If you think about the Wampanoags, right? The Mashpee Wampanoags, it took them 30 years to get recognition. Sadly, what happens is that many of those who start the fight, who begin the battle, aren't there to watch for the victory, as it just takes so long. But to the point of the question, because there are these couple of wins, like the Dan sisters, one of whom just recently passed away, the Dan sisters and the Awastini, these couple of victories tell you it's a worthwhile fight. I went down to the Tawana Nation a couple of years ago, a nation that is on the border of the United States and Mexico, and offered my services as an attorney, offered our services as a program, as they battled a wall being built through their tribal community, dissecting their reservation as they had thousands of members on the Mexico side, as they crossed back and forth over the border for ceremonies and rituals and to visit burial grounds. I offered our services as they battled the building of a wall that kept their people on two sides of a border which crossed them, and they didn't cross.
Good. Round of applause for Dr. Diamond. Always a pleasure, Dr. Diamond. And of course, we have for you as well, sir. Could be unpinned.
From there, I don't just.
Thank you.
We have our certificate of participation. This certificate is proudly presented to Dr. James D. Diamond in recognition of your participation in the 5th Annual International Indigenous People Cultural Conference presented this 17th day of April of the year 2020. Once again, another round of applause for Dr. Diamond. Dr. Diamond had told us initially his remarks would be only 15 minutes. I respectfully acknowledge what he said, but I was definitely hoping for more. And of course, as usual, he did not disappoint. So thank you very much, Dr. Diamond.